going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Thursday. Hopefully you guys are all having a great day. Allie, I'm sorry that you had a rough day. Hopefully we can help you, get some laughs in. So, we got some court. We start with the Judge Simpson case, and right out the gate, powerful one. When I don't want to spoil it too much, but Judge Simpson goes off. All right, I'm not going to spoil it. Then I got a couple other ones. So yeah, let's go. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. I don't know why I almost said best friends. Do your best friend. That doesn't even sound right. Sounds so bad. All right, all right, let's just go. Let's go. Play button. Let's go.
This is for Kyle.
Hey, isn't that special? I responded to your email. I don't know if you saw my response.
Yes.
Beeps.
That's right. Court does call the case of the people versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with and on behalf of James Dennis Whitley.
We just started, peeps. We just started.
This is people's emergency motion to modify violence in this case.
Your Honor,
Yes, sir.
I didn't file a response because we got this at noon yesterday, but honestly, we also yesterday afternoon received a discovery which we've gone over. There's some issues that I certainly have with the allegations contained in people's motion. The simplest one is under paragraph 8. It lists 4 offenses: criminal history, A and B, the same offense. 22821 is a district court case that became a felony, was found over reporting registered actions, resulted in a plea to operating law, a second offense, 31621. So that is one, that's the minor issue I have. Their description of what happened on this date contains, I think, some confusing statements.
No spoilers, Allie. No spoilers. But yes, it definitely goes down. And I'll say it. I'll say it when it gets closer to it. But real quick, I don't want to forget to shout out. Isn't that special? Thank you so much. Member of 3 months. That's awesome. Isn't that special? I appreciate it.
Paragraph 3, they say that the children saw the witness the assault, but in paragraph 5, they correctly state the 13-year-old son heard some screaming, glass break. He went into the room and observed the defendant sitting on the victim on the floor. The daughter, who was either 10 or 11, the brother thought she was 10. Mom says she was 11. Said that as soon as he got his car keys, he left. What I think this comes down to, quite honestly, in my cursory review, my assistant has looked in a lot more detail at these things. The statements contained in the police report are not 100% consistent with what the allegations are here as far as the case is charged or not. When you first asked whether or not he strangled her, she said, I will tell you that I will say that if you tell me I have to. This is not the case that they purported to be. this case is more consistent with what I explained as Judge Fink on Monday.
Magistrate Fink, but go ahead.
What's that?
Go ahead.
This Fink, did I say Mr.?
You said-
Oh, Judge, Magistrate Fink, I'm sorry. You're all your honors to me. So. I don't want to get too much into the case, but what I will say is there are a huge numbers of inconsistencies between what the alleged victim said throughout her interview. This is, again, as I represented on Monday, I don't think there's much of a chance of conviction here. I will tell you that she is here. She wrote a letter to you. I've given a copy to the prosecutor's office. I will indicate, just for the record, I explained to her that I wasn't comfortable talking to her about what happened, because my belief is she may need to talk to an attorney. I believe she is supposed to talk to one on Monday. But she wrote a letter that explains how little afraid of Mr. Whitley she is. What's also not contained in the report is the report says that she called, the alleged victim called the police, and actually that her friend Michelle called the police. Michelle's known Mr. Whitley for 20 years, and her statement to the police was, Mr. Whitley is not like this. I've never seen him mad. He's always has a smile on his face. Stunned that it happened. The children said, don't hear him argue, never seen her do anything before. Never seen him do anything before. Mr. Whitley is not a threat to the community. We look at the factor of the likely sentence. This, I initially had scored it as 0-17, but then when I looked at his record more accurately, because of the 10-year gap rule, he's going to be in grid B12, which is a 0 to 11 months intermediate sanction. It's a Class D felony. I scored for the injury to her, and I scored, which I don't agree with, but it'll likely get scored, that he exploited a domestic relationship. B2, 0 to 11 months probation. And the people are asking not for a bond to secure his presence or to protect the community. They're seeking a bond that's punitive. They want to punish.
No, they can suggest them. They can suggest that they would be disbarred, but to be disbarred, you have to go in front of the bar, and you'll have a hearing on it, and that's how you get disbarred. So a judge can suggest it and probably send their, paperwork and what they did to the bar, but no, a judge cannot just do it himself. At least that's how I understand it. Could be wrong. Could be wrong. I'm not an attorney. Haven't gone through that, but as far as I understand it, that's how it works.
Punish Mr. Whitley for what they think he did, which is not what happened, which I'm greatly looking forward to a trial to demonstrate, if they can even get her to testify to proceed. This bond was appropriately set. I guess I'll just go over what I went over with Magistrate Fink. Criminal record, 3 prior misdemeanor convictions, 2 of which exceed the 10-year gap rule that would be used in a felony. Guideline scoring, offer operating while intoxicated. It's always showed up. The only.
You know what? That's a good question. I think this is a DV case. I think it's a DV type of case. But what happens here in a few minutes, it doesn't matter what he's charged with. The attorney messes up, and yeah, you'll see. You'll see.
History of substance use or addiction is what is related to alcohol use. Certainly, he has had issues with alcohol in the past. He has no mental condition. It's not diagnosed. It's not dangerous.
Lolly.
Also, what I just said in relation to the seriousness of the offense, presence, or absence of threats. And Wilson's trauma medal. He has had no contact with her since this incident happened. Exceedingly proactive. My legal assistant has been in contact with the officer in charge since this happened.
Thank you so much, Skunk Mom. I appreciate it. And I honestly want to see pictures of your skunks. If you're honestly a skunk mom, join the Discord. We have an area for photo drops and animals. So I want to see your skunks. I honestly do.
The day that it was indicated that the complaint was authorized, she tried to turn them in. Last Thursday, warrant not entered. Last Friday, warrant not entered. Monday at 8:30, warrant not entered. She gets notification, she shows up just a little bit after 10 o'clock with Mr. Whitley because the warrant was finally entered. So he is looking forward to defending what happened here because these charges are not what the people allege. He is an employee, he works 50 hours a week with daily infrastructure. He just told me that company was bought out. That's the old company. Yeah, it's in transition. He does have a daughter in the area. He has 50-50 parenting time with her on paper. She's 14 years old. She doesn't always like hanging out with dad because he has rules in his house. But he does have a child here he communicates with daily. His friends are here. His job's here. He has no ties to any other community. As I said, as far as the other thing,
He's listening, but he's also reading. I do believe that I'm going to say most judges have mastered the skill of reading and listening at the same time, but he's reading over the complaint. So this is an emergency hearing. So he's trying to catch up and listen at the same time. And I think he does a good job. You'll see.
he's been proactive in turning himself in. And he's not had contact with the alleged victim. I have a stack of emails to him. I don't know how many emails. I'm sorry, Facebook messages, probably a quarter of an inch thick. She's sending him. I love him. I love all of these things. This is my fault. You only sent a text, a Facebook message to somebody else. I only got injured because you were protecting yourself from me. Again, I don't know what the true facts are. This is so new. What I do know.
Did he go to the hospital?
What's that? No, but I do have a photograph of his head split open from something that she threw at him, most likely a phone based on her statement to the police. That happened before these other things.
Go ahead.
She denied being strangled. She said that her head hurt not because of an injury, but
Yeah, there's one thing that Judge Simpson will not tolerate is victim blaming, or if you have any, how do I say this? If you say anything bad about the police, he is very pro the police officers that work in his jurisdiction, which, you know, I would too. If I was a judge, I would absolutely be that way because they're part of, you know, the organization. And you know, just in general, I'm pro police, you know, personally, but yeah. So if you say anything about a victim or you say anything about the police, you can tell when he changes because he cares passionately about both of those.
because she was confused. But honestly, I think it was more that she was intoxicated. She did admit to drinking. She may have been less than honest about whether she drove intoxicated or not. But at the end of the day, quite honestly, Mr. Whitley's not a danger. He's an upstanding citizen of Washtenaw County. The prosecutor's office is seeking to punish him by $150,000 bond. It has nothing to do with what her allegations were at the time and nothing with what really happened. I don't see it here. I've only had, 27 hours to look at this stuff.
Lane, you're right. You're absolutely right. Yeah, Miss Polera. And after meeting her, Miss Polera she's the nicest person in the entire courtroom. And that's not an exaggeration. She's a sweetheart.
The people have had longer than that. And I don't read anything in here, the people pointing out her own inconsistencies about what happened. And which affects, again, the likelihood of conviction. What it does just come down to, Your Honor, is Mr. Whitley is not dangerous. He's going to show up, and he's been not dangerous his whole life. He's 43. This is the first time he's been alleged to have committed any act of violence against anyone. He has custody of daughters. The mother has it. She's never made allegations of domestic violence in the past because they didn't happen. So if I read the motion, it seems to me that the biggest focus is about his dangerousness. Jennifer's sitting right in the hall. She'll come in and tell you.
Yeah, exactly, Jedi. The defense attorney has just said everything he's accused of doing. I said prostitution. Man, words are hard sometimes. I feel like it's been words. Words are hard more often than not these days. The prosecution hasn't even spoken yet. The defense attorney is saying all these things. It's like, come on, guy. You're saying way too much. Stop talking. He doesn't stop talking. Spoiler alert, he doesn't. This goes on for a bit.
She doesn't consider him a threat. Again, if the court's willing to look at it, I can show you this letter that talks about her relationship with him and the fact that she's not afraid. Didn't ask her to write it. She just wrote it. I think she would also tell you that Michelle said that Mr. Whitley, that this behavior was inconsistent with.
I'm sure one of my mods has dropped the link. You can just click it, or my Discord link is always in the description. So if you just go to the description of the video, you can jump to Discord.
Who Mr. Whitley is, based on a long-standing reputation of not being dangerous. I ask that you leave the bond as it is.
Your Honor, I think what this ultimately comes down to is the people are very concerned for the victim in this case. I'm concerned that she's writing a letter. I'm concerned that she's saying that this is her fault. I'm concerned that she's saying.
All right, this is a really bad time to make this joke, but I'm going to make it anyways. Hooked on phonics. The funny thing about hooked on phonics is it doesn't make sense. You know why? Because if it did, it would be called hook. I think you spelled it. Therina, I think you're already calling this joke out. Hooked on phonics. Work it for me. Yeah, you already know the joke. Who was that? I think that was Brian Regan that did that. Therina, I think we just became best friends.
Saying that she provoked this in the form of throwing something at the defendant. To me, those sound like very telltale signs of someone in a domestic relationship who has been victimized previously. I think here, what we have is a woman who ended up in the ER, receiving 3 CT scans in the head and face area, 2 X-rays, 1 for the chest and 1 for the wrist, who had 2 kids who were around when there was a domestic dispute between her and her partner. And I think it is extremely concerning to me that the fact that when the victim said she had head pain, defense counsel characterized that as a symptom of heart intoxication. It was explicitly stated in the police report that the defendant ripped her off the bed, slamming her to the ground, during which she landed on the right side of her face and was unsure if she even lost consciousness at that point. That seems to be the root of why she would have gotten the CT scans, being concerned for a concussion. The victim also sustained multiple visible injuries, including cuts, bruises, red marks on her upper body and her neck. I think that count 1 on here is charged in the alternative of assault, GBH, and or strangulation. We do not need to prove simply strangulation in order to proceed on the felony here. We can proceed on the assault, GBH, which I do believe would be satisfied based off of the victim's requirement or required medical treatment as a result of this encounter with the defendant. Ultimately, I believe that the PR
Yeah, the PR bond. Now, just a kid, I'll answer that in just 1 second since I'm paused. But you heard when the defense attorney said Judge Fink gave him a PR bond, and Judge Simpson instantly corrected him. Magistrate Fink. It's Magistrate Fink. I think that was kind of a slight at Magistrate Fink. I'm not sure. I'm not sure. But I think Judge Simpson is upset about the PR bond. And that's why he made that comment. And it comes back up here in a minute. And just a kidder, I'm trying. I've got two different sources that I'm trying to get in contact with him. Even after I met him, I'm not getting any responses. My guess is he doesn't really appreciate the YouTube community, what we do and watch court and show court. I don't think he appreciates it as much as we think he does. Yeah, I'm hoping that I'm wrong, but I've got a judge trying to talk to him, and now I've got someone else that has a little insight that's trying to talk to him, and I'm getting zero responses. So I'm still trying. I'm not throwing in the towel yet, but I am trying.
Bond here is an abuse of discretion. And we did make an argument at arraignment for the $150,000 bond in this case, and I would be renewing that request today.
I may reply, Your Honor, briefly. I'm making it clear this alleged victim was previously the victim of domestic violence from her deceased husband. That can explain maybe some of her reactions and some of the issues that she had.
What does that mean?
Her children, and she said this had never happened before by Mr. Whitley. Never happened before. Okay.
But I don't understand the first part of what you just said,
Well,
and how that relates to this.
She may
All right, I don't know why I have this in here. Yeah, sorry guys. You just saw a little inside of yeah. Anyways, let's go. Who said? Oh, Abe. Abe's here. The court turns off chat. Obviously, he doesn't have any interest in making any restricting chat's disgraceful action. Yeah, I don't agree. It's not a disgraceful action. I don't agree with that. We've talked about this before, Abe. We have. We really have. And I like your opinions, but I disagree with this one. Or no, I don't know if I'm not going to say I like your opinions. I appreciate that you leave opinions, but yeah. Detective Rachel, thank you so much for the $2 super sticker. I appreciate it, Rachel. Hopefully you're having a great night.
Simply strangulation in order to proceed on a felony here. We can proceed on the assault with age, which I do believe would be satisfied based off of the victim's requirement or required medical treatment as a result of this encounter with the defendant. Ultimately, I believe that the PR bond here is an abuse of discretion.
Yeah, that would be really strange if it was my bank details. No, I think I was uploading a video while I was grabbing this clip. So the sovereign citizen video, I think, just finished, and I forgot to edit that part out because I got the notification that it finished uploading. So I went to release it. I think that's what that was. I'll go back and check after this video, but no, there was nothing there. It was just YouTube Studio. That's all.
And we did make an argument at arraignment for the $150,000 bond in this case, and I would be renewing that request today.
I may reply, Your Honor, briefly. I'm making it clear this alleged victim was previously the victim of domestic violence from her deceased husband. That can explain maybe some of her reactions and some of the issues that she had.
What does that mean?
Her children, and she said this had never happened before by Mr. Whitley. Never happened before.
Chris, good to see you, Chris. You have reached Rachel status where I'm going to pause every time you jump in and acknowledge you. So yeah, good to see you and Rachel in the same chat.
Okay.
But I don't understand the first part of what you just said, and how that relates to this.
She may have some PTSD related to the crime before, but that doesn't mean that what Mr. Whitley says happened is wrong, or what how she answered the question. The first, and quite honestly,
Mr. Bennett, I'm trying to figure out what you mean by some PTSD from before. You're saying her reaction to all of this is in reference to some PTSD because of stuff that happened previously?
the process.
Yeah. So victim shaming. Victim shaming is what he's doing. Even if he's right, and the victim doesn't feel afraid of this man, and she wants this. I don't know if there's no contact. I don't even know if they talk about the no contact order. This is an emergency bond hearing, but even if everything he says is correct, he's still assuming a lot. PTSD from former domestic violence. Why would that have anything to do with the charges pending right now? I don't get that. Also, Tiffany, you haven't missed a ton. I'll sum it up in about 10 seconds. Emergency bond hearing. Keep trying to say prostitution. The prosecution is trying to raise this guy's bond. Brought him in. The defense attorney is victim shaming and saying this guy's a saint essentially, even though he strangled, but allegedly strangled, this woman, and now the defense attorney is claiming the victim has PTSD, and that's the issue here. Why would you, even if she did, why would that even be relevant? Why would that be relevant if she did have PTSD from a former relationship? It's not. Yeah. I have a lot of emotions about this case too. So I'm just going to let it play for a little bit.
Peter is making some comments that are speculative about her being a classic victim of domestic violence, which she was in a prior relationship. So the fact that the prosecutor sees that is unsurprising. That's what I'm saying.
Yeah, I don't know if I'm going to be welcome in Judge King's courtroom anytime soon. After I made a complete mockery of, him trying to be funny with me, and I failed miserably at it. I really did. I shit the bed. I shit the bed on a great opportunity. So, yeah. But yeah, I'll be back, and I'll let him arrest me. It'll be fun. He let me wear his robe and sit on his bench, so I guess the next thing is getting arrested.
Okay.
And as far as that he ripped her off the bed later at the hospital, that's not what she said. She said they fell off of it. I don't know what she's going to say in the statement. And what's important about this, no influence whatsoever by Mr. Whitley. He has stayed away from her. He doesn't want to interfere with what she believes happened. And he's not trying to influence her to do anything. I find it surprising that they're alleging that she's in danger, the prosecutor. They don't call her to show up. She reached out to a friend of my client.
Call her to show up to do what?
Today, to say I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock with 24 hours notice, I couldn't.
All right, I told you I'd give you the warning. Here's the warning. It's about to go down.
Got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
All right.
All right. So that was the best thing Judge Simpson could have done. And I applaud him for doing that. As a judge, when you get emotional, you have to step off the bench because he got angry. He felt insulted about the comment that the defense attorney just made. And he said, you know what? I am raising my voice right now. I need to step off the bench. Here's the problem. I don't want to spoil, you know what? I'm not going to spoil it. Not going to spoil it. Let's just say the defense attorney did not learn his lesson of getting yelled at by Judge Simpson. If any normal person, I'm not going to say normal people, if, anyone in my chat, let's say that, all 260 of us were sitting here and we were defense attorneys and Judge Simpson just walked off the bench that way and said, I need to take a break because I'm yelling at you and I'm angry with you and I can't let that affect my decision-making skills. I can't. The first thing that we would have said when he came back is, Judge, I'm sorry. Didn't mean to cross the line. I'm emotional about this case. Something. All right, let's go. No, we are not normal. We watch court for fun. We watch court for fun and we watch court for entertainment. That isn't normal. So no, that's why I call us all weirdos. So yeah, we aren't normal. We're court weirdos.
14A District Court for County, Washington. Session, the Honorable Judge Simpson.
You may be seated. Court recalls the case of the People versus Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in this on behalf of Mr. Whitley, standing to my right. Mr. Whitley, can you state your name before, please? James Dennis.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn. The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing. Without notice to any side, I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow. All right.
Just look at Judge's face. I don't want to say much. I kept this in for a reason. Just look at him. The silence is deafening.
They're bringing him.
All right, yeah, Thorino's right. It's why I love Judge Simpson too. I think that was the right move. He was pissed, and he was, yeah, he felt insulted. And when you're angry as a judge, you're going to make a decision that's is not going to be wise. So I applaud him for doing that. And yeah, so I will tell you this: I will be watching tomorrow, and I'm going to go live for that clip. So keep a lookout tomorrow. It's going to be a random impromptu in the middle of the day live for whatever happens as a result of that. And I imagine it's going to be, the defense attorney is going to be like, I'm so sorry. Whatever. But yeah, I'm going to be playing it live. Anyways, okay, let's move on. You guys are awesome. Let's see. Mary Simpson actually backed the door for emphasis. He did. Thank you so much, Mary. I appreciate it. Also, I got a PayPal. Jenny, thank you so much. Just because. I love the just because PayPals. You can just because PayPal me all night long. I'm just kidding. Don't. that sounded a lot worse than it was supposed to. All right, let's go. I don't even know what's next. I don't know what's next. We still have Judge Perkins. Let's go. We have a lot more of the video to go. We still have another Judge Simpson clip. I think I have still 2 more Judge Simpson clips. Yeah. All right, Judge Perkins, let's go.
Kenneth Owens, case number V13-255-624, V13-255-724, V13-255-824, V13-256-624, V13-256-924, V13.
All right, this dude is reading. He just has a lot of charges. Mike, thank you so much. I didn't see that. You said that yesterday. My Cash App, for whatever reason, does not give me notifications anymore. So unless I open it, I don't see it. I don't get emails from them anymore. I don't get phone notifications from them anymore, and I used to. So I apologize for that. But thank you so much, Mike. I appreciate it.
257-024, V13-257-124, V13-257-224, V13-257-324. Appearance for the record, please.
Good morning, Your Honor. Alexa Schneider for the people, P80322. I have the issuing officer present.
Your Honor, Pauline Soroki on behalf of Mr. Owens.
All right, good morning to you. Mr. Owens, state your name for the record, please.
Kenneth Owens, Your Honor.
And good morning to you and Investigator Charleston. Good morning to you.
Good morning.
State your name, please, and your badge number and
Investigator Charleston with Detroit Animal Control, badge number 11.
Very well. Good morning to you. All right. What's is there a resolution here? And then let's also let Mr. Let's not forget another key component in this. Mr. Jeffrey Brooks. Can you state your name for the record, please?
Jeffrey Brooks.
And I believe you're a witness for the people. Is that one of your witnesses, Ms. Schneider?
Yes, Your Honor.
All right. So what's going to be the resolution?
Your Honor, today is the date and time set for trial. Mr. Owens has a number of tickets. He's come into compliance on the 3 no dog license tickets. We're willing to dismiss those today in light of him being in compliance. There are some factual issues and a need for reciprocal discovery on the no dog restraint tickets. So I believe Attorney Soroki will be joining me in requesting that Mr. Owens be assigned an appointed attorney, and we can share that reciprocal discovery prior to our next trial date.
I would, Your Honor. I think it's the best way to go in this matter.
And Mr. Brooks, do you understand what's going on? Has somebody spoken to you?
It's kind of the other way around. I think she gives him a hard time a lot. But yeah, they she gives it's yeah, I don't know. Miss Mason as well. They but it's not the judge. Like both of them get into, verbal arguments with the defense attorneys a lot. I don't really think it's the Judge Perkins that often. Yeah. I got to see her in person though. This prosecutor, she came into the courthouse. She's tiny. I don't know, like seeing these people on screen, you think that, they're, I don't know. I don't know what to say, but when she walked in, she was short. She was Judge Bryan short. So it was interesting. But the funny thing is she came in and started talking, and Debbie Baker literally whispered into my ear and just said she has a prosecutor voice. You know how some reporters have, or journalists have reporter voices? She has a prosecutor voice. She does. She came in, she made her presence known, and she has a very, very prosecutorial. I don't know what the right word is, but you guys know what I'm saying.
About that?
No. I just know I made a complaint. I know that much. And I spoke to the officer, and the officer told me a trial date. I mean, a court hearing date.
Very well. And are you a neighbor or what?
Yes, next door neighbor.
Okay. It's unfortunate that she couldn't resolve this matter amicably between the two of you, but
They have many cases, Your Honor, civil and criminal.
so it's an ongoing thing.
Yes.
What do you have to say, Mr. Owens?
Technically speaking, Your Honor, he is not my neighbor. That would be him lying under oath. He lives next door. He owns the home next door to me. He doesn't reside there.
Okay. So it's never gonna end then, huh?
No, I
Two
mean,
grown men. Wait a minute. Two grown men are gonna keep back and forth.
Your Honor, it's not me. I promise to God, it's not me, Your Honor. I don't bother nobody.
That's what everybody says. Okay. I didn't ask who it was. It's just gonna keep on going though, huh?
No, Your Honor, I'm not trying to keep going with nothing. I'm just trying to live in peace. I have 4 kids to take care of, 1 in college, 2 on the way. I don't have time for frivolousness and ignorance. I don't have time for it. I own my own company and I work.
Here we go. All right, it's enough said. See, there it goes. I saw Mr. Brooks say, no, he doesn't want to keep it going. But you want to talk about ignorance and things like that. And I guarantee you, if I ask him about these dogs, he's not going to feel that that's ignorant. But there you go. All right, I'm going to give you an opportunity. Do you need a lawyer appointed to you, sir?
Yes, Your Honor.
My mom used to always say, it's not what you say, it's how you say it. And I guess when you say things like that way, it's not gonna resolve itself. It is gonna keep on going.
Your Honor, I don't mean to be rude or disrespectful to you, and no matter what, sir.
No, you're not being disrespectful to me. Yeah, I think you're being disrespectful to Mr. Brooks.
Your Honor, this has been going on for 3 years.
I know. That's what I'm trying to say to you, sir. Isn't it time for it to be put to bed and you guys become better neighbors? Isn't it time?
Yes, Your Honor. I concur, but when you can't.
Okay, so stop. So when you say but, now you're gonna put a barrier up in between that. If you agree with me and say it's time to be good neighbors, then now let's put this stuff behind us and become good neighbors.
Kidder, it's good to see you. Watch this clip. What comes to mind when you watch this clip? If you just got here, you might have to rewind a little bit, but this Judge Perkins clip, let me know what comes to mind. You don't have to say it in the chat. You can PM me.
I'm more
Don't put the but in there. Are you willing to become a good neighbor, Mr. Brooks?
Yes, I would love that. I love all my neighbors, Your Honor. Yes,
I know I'm asking Mr. Brooks now. Are you willing to become a good neighbor?
Yes, sir.
All right. So now, when you add extra stuff to it, he says he wants to be a good neighbor. You want to be a good neighbor. Well, let's put this stuff behind us. Let's be good neighbors. All right.
Yes, Your Honor.
All right. What's your phone number, sir?
313 290 51 2-2.
Okay. What I'm gonna do is I'm gonna reset this for a pretrial date, for, the 28th of, June.
I can't admit or deny that. I don't know. I don't know. You know the story, but I wasn't there for her open house, so who knows if she did or not. It was just a really interesting situation.
Mr. Brooks, you're more than welcome to come in to that pretrial date. You don't have to if you don't want to. Today was a date and time set for a trial, so it was a case of you having to come in if you want to put your testimony on. But since there's no testimony, the parties need some time to get some further discovery and things like that. We'll allow them that time to do that. You're going to need to Mr. Owens to answer the calls you don't necessarily recognize, because hopefully one of those calls will be that appointed attorney. We'll put that paperwork in for you today. And then the next court date will be June 28th. I will dismiss B132-55624, B132-55724, and B132-55824, the dog license tickets, because you apparently have come into compliance. All right. The other tickets will remain open, and you don't have to wait until this is over with either to start becoming good neighbors. You know, you can do that anytime. Hopefully that happens right now. And then you act like grown men should be able to discuss and talk things out. And then this kind of situation, if the court has to get involved, this is what we're for. So you guys don't bicker amongst each other and somebody potentially raises to the level of somebody getting hurt. But if you want to be a good neighbor, it can start right now. All right?
Yes, sir. Yes, Your Honor.
All right, I hear both people agreeing. Hopefully, it can come to some sort of resolution that's amicable for both of you two, and then you can start that process. All right?
Yes, sir.
All right. Investigator Charleston, they'll get in contact with you if they need you next time. You just be safe out there, and Mr. Owens and Mr. Brooks, both of you have a very good day, and best of luck to you both. All right?
You said 628, right, Your Honor?
628 at 8:30.
8:30. Cool.
All right. If that attorney hasn't contacted you by 628, we're on that.
All right, just real quick. This guy's wearing a nice suit. He dressed properly for court, and I will always appreciate that. But he's saying cool beans in a decked out suit. Kind of like, I don't know. First thing is, who says cool beans anymore? Yeah, all right. I'm not going to say anything else. Let's finish this clip.
We will automatically appoint an attorney on the spot. All right.
We got Judge Simpson interrupting. Of course, because I'm awesome at editing.
Contact with you if they need you next time. You just be safe out there, and Mr. Owens and Mr. Brooks, both of you have a very good day, and best of luck to you both. All right.
You said 628, right, Your Honor?
628 at 8:30.
8:30. Cool.
All right. If that attorney hasn't contacted you by 628, on that day we will automatically appoint attorney on the spot. All right.
Cool beans. Thank you, Your Honor.
All right. Very well. Both of you have a very good day. All right.
You as well. Have a blessed one.
All right, Investigator Charleston, you have a good day. Be safe. All right.
Thank you, Pauline. I appreciate you very much.
Good luck.
Excuse me, Judge Perkins.
Yes.
Are you down at juvenile court?
No, that was probably Judge David Perkins. No relation, but he is a good guy.
Okay, yeah, because I used to work at Black Family Development, and I was like, that ain't the other Judge Perkins. All right. All right.
He was here, and then he went over to probate court. So now he's at probate.
Oh, okay.
All right. All right.
Bye-bye.
Bye. Okay, last but not least.
All right. Yeah, that was a little a little palate cleanser from the first one. I don't know what's next. Hold on. I don't know what's next. Oh, yeah, I'm laying on heavy today. I am laying on heavy. Get Judge Simpson getting angry, neighbor fight, and now we have a Judge Stevens clip. This one isn't drama induced, but the crime. You guys are all gonna raise your eyebrows. Cha, good to see you, Cha.
10-10405 is called. Denise, is it Vidrine or Vidrine?
Adjourned.
Is here. And this is, again, one of these, we've kind of collected several of the cases where people are on extended lengths of probation because of generally embezzlements or thefts, like in your case, an embezzlement. And it is a matter of long-term payment of the loss. And this is actually probably the largest embezzlement in my career here that you're dealing with, of 400, almost $500,000. So you were placed on probation. We are down to what level?
Okay, her case is, the HRP still keep the case active, and this was 10 years adjudicated.
I understand. I mean, how much is her, what is the amount of money she still has left?
She has a remaining balance of $196,737.67.
$196,737.67.
37
Okay, almost $200,000. It's been reduced by about a half over this long term, which is now going on 12 years, this case. So how much are you paying per month?
$550.
Okay, and is that the most you can do, ma'am?
Yes, sir. I'm sorry. I wish I could do more, but right now I have medical problems and I can't pay any of my medical bills. And so it's just a matter of time before they quit seeing me and I'll be back in a wheelchair.
Cha, I appreciate you because you watch court as much as I do. So I appreciate and respect you. I will always call you out. I will. I hope you're having a great night, Cha. At one of these days, I'll figure out how to actually say your name. Chadascudum. Chadascadum. 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 You know what? I'm just gonna stick with Cha.
I'm doing the best I can.
If I'd been the victim of an embezzlement like yours, where you had a position of trust and you pilfered almost $500,000 from me, I'd have a hard time sympathizing with you.
I understand.
But it's what it is.
Your Honor, since her last,
I just wish you wouldn't have done that. Really, I mean, at the end of the day, not to scold you, but some people need money. Really, you needed $500,000.
Right.
You needed $500,000 for necessities. No, that was just.
She's paying $550 a month. $550 a month. She embezzled $500,000. And here's the big issue with this, and nobody wants to say it, but she's not young. The hard part, she embezzled $500,000, $500,000, and she's paying $550 a month back. Where did the money go? Where did that go? That's the question. That's the question.
Terrible thing. Yes, sir.
Your Honor, since our last appearance.
12 years. 12 years. So he said that 2 or 3 minutes ago that she was convicted of this 12 years ago, and she's been paying $550 a month for that long. And she must be paying extra payments because the balance is about half. They say like 200 something thousand now. So she's half the balance in 12 years. and you know, I believe that would be a lot more than $550 a month for 12 years. Just saying.
In November, she has paid a total of $3,312. She is making payments every month.
And it's how much per month?
She's right now, her last order was $550 per month. She has been paying that every month since November 2023.
Anne, thank you so much, Anne. I appreciate it. Very generous super chat. Hello, Colin. All the cooligans. Hope everyone is having a great evening, lurking as usual. Well, I appreciate you being here, Anne, as always, and thank you so much for the super chat. I appreciate that as well.
So that ends up being about 6,500, 6,600 a year. Which means we're still looking at about 30 years.
More than that, give or take.
The math doesn't work out, does it?
Yeah.
There's nothing we can do.
Oh, I should have edited these out. My internet kept dropping today. So this is not you guys. This is my internet. I think it was 4 times today I lost internet for about 5 minutes straight. So yeah, I just fast forwarded a minute. Another 30 seconds. All right, here we go.
What is
Good night, John.
There's a loss that the
Jonathan,
victim's
Jay
going to
Hart.
have to have at the end of the day. It's just, unless you win the lottery.
I don't get it.
That wouldn't be, I don't think I would be happy about finding out about that.
Yeah.
Well, but the math doesn't work. I mean, he'll never get paid back this rate. But it's what can be done under the circumstances, which sometimes the law isn't perfect. It's supposed to have a quid pro quo. You're supposed to balance the scale, and it's tipped on a crime by punishment and restitution or whatever. In this case, there's really no likelihood that reasonable that the scales are going to balance. It's going to be tipped against the victim.
She did remit $210,000 before granting probation for restitution.
I can't remember.
I don't have any 9-month members. Not one. The longest I have is 6 months. So if you've been a member for 9 months, you're breaking YouTube, and I appreciate it. But yeah, it's not possible. The longest members I have is 6 months because I was demonetized for 3 months, so that time didn't accumulate. But if I missed your shout out or if I missed your milestone chat, I do apologize, but it's definitely not 9 months. You may have been here for longer than 9 months because I actually turn a year old for my channel next month, so that's possible. But from the time I was monetized, it's not. But if I did miss it, I do apologize.
When that occurred, how much detail we went into of where in the good Lord's world did $400,000 go? I can't remember what that story was, but whatever it was not something that resulted in the saving of a life or something like that. It wasn't for a good purpose, a worthy. There wasn't a good reason for this. Sometimes there's just an answer that fixes the problem completely, and this partially fixes it, but We still got a long way to go on this. Anyway, is there anything else to add on?
No, just, we'll still keep monitoring the payments and
We'll just, I guess, review it in another 6 months, just to make sure that we're still getting some kind of repayment for the victim in this case.
yes, Your Honor.
Anything you want to add, man? No.
I'm trying very, very hard, but with my medical bills, I can't do no more. I mean, my other choice is I'll die. And then he won't get nothing. I mean, I'm trying really hard.
That's such the wrong word, usage of words in this situation. That's not the right way to explain your situation away. There's a better way to show a little remorse for his loss of $400,000 to make it sound like we're supposed to be sorry for you. Well, I'm sorry you're sick and ill, but I'm sorry that this prolific theft occurred. This is prolific amount. But don't twist it that you're the victim. Don't make it sound like you're the victim.
I'm not the victim.
You're not. You're not. Just keep paying. Keep paying what you can. You can do. And once again, this is one of those where everyone feels sorry for the victim. Embezzlements are contemplated, thought out, planned, and this one was a prolific amount. It's not a good thing. Your goal is to pay this all back if possible, if humanly possible. Pay it back. Right?
Right, exactly.
You're the one who set the bar. Not us, you did.
Mhm.
All right. Okay. That is all. Please get a reset.
Here's this indigent affidavit.
Where's
All right. Yeah. Don't steal $500,000. Don't do it. Don't do it. Don't embezzle. Sashina, thank you so much for the 5 months. That is awesome, Sashina. One of my longest supporters. I appreciate it, Sashina. You are awesome. April. I should bring it up. April, thank you. Thank you so much. Member for 1 month. I appreciate it, April. Thank you. And Lexa, the original Lexa, member for 3 months. Thank you so much, Lexa. You're awesome. You guys are all awesome. And the person that was just saying you've been a member for 6 months. I was just looking for your name to see if I missed maybe if I missed your milestone, but I was just scrolling through the members list and I've gone down to the people that are at 3 months and your name's not there. So I'll go back through, but I think there might be something wrong there. I don't know if it's YouTube. I don't know what's going on, but yeah, your name's not at the top of the list. Lolly, yep. Lolly, 6 months. 6 months. Thank you so much, Lolly. I appreciate it. You are awesome. You are a legend, Lolly. All right, next clip. I think we're going back to Judge Simpson. I think we're going to do a funny one now. I hope. Yep.
Across the case, people versus Joshua Blue. Mr. Blue?
Joshua Blue, I'm here.
Thank you, sir.
Well,
all right, his license status? Why, has he been driving?
Yes, sir.
You have been?
Yes.
Uh-oh.
I got it cleared up.
Did you?
Yes, sir. The day after I caught the ticket.
You got it cleared up?
Yes, sir.
Is that what they told you?
Yes, sir. The day after I caught the ticket.
I'm looking at your record here.
I paid the fine. They told me the day after I
Did
caught
you?
the ticket.
And then they
Yes,
told
sir.
you you'd have a license?
Yes, sir.
And so you've been driving around because somebody told you had a license?
Another judge told me that, sir.
Seriously?
Yes, sir.
So you're gonna believe the other judge or me?
Both of y'all.
All right, never mind. That was a setup question. His license valid.
If you want to do this, you can don't charge it today, Your Honor. And of course, if we accept that admission, we dismiss the original charge.
Is that what you want to do, sir?
Yes, sir.
Counsel, is that what?
That is what we discussed, yes, Your Honor.
All right. He was getting a little worried there.
Yeah, you got me.
He's thinking, no, what'd you say?
Yeah, you got me. Yeah.
He was looking, if you saw him on the screen, he's looking all around like he's trying to find some paperwork or something to say. All right, Mr. Blue, you admit responsibility to the fact that on the date and time of February 21st, 2024 in Pittsfield Township, that you double parked a motor vehicle.
Yes.
Court will accept that.
Yes, it does. All memberships count, Carrie. All memberships count. You guys are all awesome for being members. I wasn't discounting anybody's membership at all. I really wasn't. I was looking to see if I missed a milestone check. So that's all I was doing, which is why I said I don't know if YouTube's messing up when I'm looking through the members, but I'll tell you that I know Denali Mike. He said he's been a member for probably 5 months, and I know he has, but his name's not on the list either. So I think my YouTube list might not be accurate. So I do want to shout that out real quick. But yeah, Carrie, thank you so much.
That admission. Fines and costs of $180. When can you pay that?
So, how my account set up?
What?
So how my account set up, right? I want to know could you do like 30 days? Because I just had a newborn and
in jail?
No.
Oh.
To make
I
that
didn't know what
payment.
you were asking me for.
No, sorry. Can I get like 30 days to make that payment?
What? Oh, because you just had a newborn?
Yes, sir. And I got 5 other kids, so got a gang of kids.
Wow.
And I don't want to. I don't want to make a promise that I can't keep. If I say a week, I might not be able to pay it in a week.
So you got 6 kids?
Yes.
Wow. Was this one a boy or a girl?
A girl.
All right, Mike. Yeah, I just found you. It says 5 months. You rejoined 22 days ago. So you have 8 days before your 6 months. That's what it shows on my end. I'm not going to do this for everybody. Like I do have a list of all of the members though. I can see an active list. But yeah, no, Mike, you're just a little over a week from your 6 months.
Wow. 6. No, Emily, you're not talking to me. So you need 30 days?
Yes, sir.
I had 6 kids. I take the jail time just to get away. I'm just saying. But that's me. Wow. What day? What day was she born?
She was born the 27th of last month.
Oh, that's like 27th of April?
Yes.
Oh, that's like newborn.
Yeah, yes.
He gonna need a breather. All right. Pay it by August 31st. Don't forget about me.
Okay.
I'm giving you some time out there because.
All right, thank you.
You're welcome and congratulations.
All right, thank you.
On this new one and the other 5.
Yes, sir.
All right.
All right.
Take care, Blue.
Yeah, you too.
All right, we might be going to the last clip now. I don't know what it is. Yeah, so
Close case, People versus LaShawn Covington.
oh, another Simpson. Okay, we're just gonna keep rolling with Simpson. All right, let's go. Oh, this is from today. Yeah, I don't need to say much about this. We'll just let Judge Simpson take care of it.
What your Honor, Assistant Public Defender of the FAFO, was held with no one actually just about the yes.
Pardon, Your Honor. Sean Covington.
Thank you. What are we doing?
We would have to go there on this matter for discovery.
And Your Honor, attorney would like to respond.
Go ahead.
Your Honor, at this time, the people will be requesting that the defense bond be modified to the original 100,000 cash surety tax at arraignment. This defendant failed to appear in 2023 in this case and exam and proper witness. He was also out on probation for ad stock and picked up 2 felony charges, I believe. And I believe in this case, he was released on May 7th, and it showed on, actually, he still has a warrant for a BOP, other non-support warrants. And the people believe that in this case, the bond would be appropriate at 100,000 given the serious nature and concern for the victim's safety. In this case, the victim and defendant come in, the defendant was at the residence with their daughter. The victim picked her up. The argument began while they were arguing. The defendant pulled the gun from his waist, cocked the gun as if to load around, pointed it at the victim and also at their car that their child was in. The victim was in fear for her life, and he struck her with the gun 3 times and then fled. When the officers talked to the victim, she had noticeable swelling above her left temple, a cut above her ear, and blood on her shirt. These were also concerned given the defendant's past history of assaultive and domestic violence charges, as well as dismissed domestic violence charges. So maybe asking that the bond be set at 100,000.
Response. How did he come into custody?
I was in Detroit.
Okay. How'd you get into custody? Did you walk in or were you picked up?
I was picked up in Detroit.
Mr. Allen.
A case out there. And then I handled all the case. I came out here. I got discharged off of probation. I had to stand in Washington County for about 7 years. So when this came in,
Your Honor, he was picked up originally, but I think that this second attempt at bond increase second bite at the apple. He was released. He's coming to court today. He's ready to.
But hold it. While he was out, basically absconding on this case, my understanding is he picked up other cases?
That's the people's understanding. While he was on probation for aggravated stalking, the judge slaves court.
Those are support cases, if I'm correct. Yeah.
Or it might be on 14. Arnold had a VOP hearing on 5/2, the judge said.
The initial was a failure to appear when we were before the thing. I did that arrangement for him. And there were 2 months of time where he was in the hospital, if I recall, and he suffered some burns as the court came through.
Hold on a second. Because back.
My internet has been worse than normal today, than usual, and my internet's already shit. So it's been a lot worse today. So it absolutely could be me. It could be on my end, and I apologize to everyone. And thank you for hanging out with me tonight. But yeah, it absolutely could be me.
Just looking for a date on this. I don't know that he. The defendant just didn't come into court. He was incarcerated in Wayne County, January of this year. And then proceeded to send us information for a plea by mail. Requesting a trial date review a bond with a request for dismissal due to the hearsay clause, and Washington County has no jurisdiction over me. Because he's a permanent resident of Wayne County. Yeah, go ahead.
At the arraignment, we were going back and forth with our magistrate Pink and I, and she said, I won't quote her exactly, but the summary of it was, let him out on bond because some of it was confusion. He should be holding himself to the same standard as an attorney, but this was kind of an attempt at self-representation that went horribly wrong. And so as you can see, he's here now with an attorney. He's coming into court to address these charges, to address everything that's happening. He's not a flight risk judge. He's here now, so I would say that.
He's not a flight risk? Where was he?
He was in the hospital for 2 months, Your Honor.
When?
The court date in question, I remember it was April 4th, and he was in the hospital at that time.
Now, your assistant prosecuting attorney, Morgan Barroso, and I have the people looking back at our notes. What we see is that this is a 2022 case. He was set for exam pro se on March 7th. The victim was present, willing, and cooperative. The defendant appeared on Zoom. The court, they tried to proceed with the exam at that date, but the defendant had insurmountable technical difficulties, so it was adjourned out to April 4th. And on April 4th, the defendant didn't show up.
Did not
show up. He failed to appear, and he was put in bench warrant status. After that, on the 11th of April 11th of 2024, over a year later, he's in custody in Wayne County and mails in this misdemeanor plea by mail to the court.
Correct.
So he's in bench warrant status for over a year. And obviously there's something else, other context with law enforcement going on because he's in custody in Wayne County during that time while in bench warrant status. I'm sympathetic to him being in the hospital for a couple of months in there.
Jody, it's really good seeing you. Hopefully you're having a great night. And yeah, take care of the youngins. As always, you're awesome.
But that doesn't explain the other 10 months plus where he was in bench warrant status and failed to turn himself in. At this point, I think that there's an issue with his bond being where it is and with him being out of custody, at least without having a GPS.
Well, but he didn't appear for a preliminary examination.
Correct.
This lawyer informed me that I have a case in Washington County for a different reason. So at that same time, my lawyer told me to call down here, get on video camera. I was doing everything on video camera from the hospital. I saw you one time on the camera. So
It wasn't my preliminary examination.
because I was in the hospital, so technical reason.
No. So then, after you missed the preliminary examination, what took you so long to turn yourself in? Well, you didn't turn yourself in, you got picked up.
It's like Magistrate Garwood says all the time. I tell this to my clients. I said, look, if your cell phone bill goes out, if cable goes out, you're going to pick up the phone, you're going to call that and get that resolved immediately. And
I don't know if quoting Magistrate Garwood is convincing to me.
But what I'm saying is, Your Honor, I explained this to him. He wasn't represented before. He didn't understand. He tried to represent himself.
Oh, I think he understood. He understood the date. He's giving me his excuse that he's in the hospital, and then we don't see him for 10 months. And I don't know why a bond was set when we finally get to him in the amount that it's set at. In my opinion, that's a clear abuse of discretion. He didn't appear for 2 court proceedings. Well, appeared at 1. He wasn't, I don't think, supposed to be appearing via Zoom. I think Judge Perry did the best she could and then couldn't proceed with that. And then he was supposed to appear, didn't appear, and then disappears. And I think has committed other offenses, because what was he locked up in Wayne County for?
It was a obstruction of justice, and I took care of that case. I came back here, I got dismissed off probation. Judge,
All right, everybody. It's that time. It's that time. I'm going to peace out. Thank you, everybody, for all the super chats, the membership milestones. Rachel with the super sticker. You guys are all awesome. Thank you for hanging out with me tonight. The chat was awesome. And thank you so much to Jenny for the PayPal. I appreciate it. And Denali Mike. I am sorry I missed your Cash App yesterday. Yeah, I don't know why my Cash App's broken, but I appreciate it. So you guys are all awesome. I'm going to let it play out. Let's go hang out on Discord after this. So if I can get a mod to drop the Discord link for anyone that doesn't have it, that would be awesome. And yeah, I will see you all tomorrow if I don't see you in Discord in about 10 minutes. Until next time. Bye.
bear with me, because I lost my lyrics, I lost my whole day. So I had to get my body together. And then I promise her I'll come back and take care of this, because I need to get this time.
Thanks, Charles, for the 3 months. That's awesome, man. I appreciate it so much. Thank you.
I lost my whole day, as you can see. So,
I understand that. I'm glad it's worked for you. All I'm saying is you haven't appeared at these proceedings. You didn't turn yourself in. You got picked up. And that's the only reason that you're here. Otherwise, we would probably not be seeing you. As I've said, I think it's an abuse of discretion that this bond was set as it was. Your bond now will be $50,000 cash surety, defendant's remanded.
Okay, bye. I want Judge Simpson to say it just once.